Mr. Stewart, the extent of the government's authority to attach conditions to government benefits is a very difficult area of constitutional law and potentially quite a dangerous one. And as Justice Thomas pointed out, the situation here, maybe our precedent should be extended to cover this situation, but this is quite unlike any of the other cases that we have had concerning that. So my question is, if we don't agree with you on this theory, does that mean that you lose this case?
I mean,
you have another argument.
I mean, I guess it depends on what you mean if we don't agree with you. If you think that this is the legal and constitutional equivalent of prohibiting Mr. Elster from selling shirts with the mark Trump too small, then we would say it's unconstitutional, at least applied in that setting, because we don't think that any government, state or federal, could prohibit Mr. Elster from selling those shirts. That is constitutionally protected expression. If you think that this is meaningfully different from a prohibition on speech, it is a condition on the federal benefits that go with trademark registration, but it still warrants heightened scrutiny. We would say it can satisfy heightened scrutiny under those hypotheses, because here, I mean, it's not just a government benefit. The particular government benefit that Elster is seeking is enhanced mechanisms for restricting the speech of his competitors.
Mr. Stewart, I'm sorry to interrupt, but I just want to see if I understand your response to Justice Alito. And I may not. But if we put aside the emphasis on whether this is a government benefit and try and avoid writing a rule that might have ripple effects outside of intellectual property law, right? And we've been discussing, this is quite unlike a lot of government benefits. And focus instead on history and what that informs us about the use of names in this context. There's a long historical tradition, right, of the living person name, just as there is with geography and other things like that. There have always been content-based restrictions of some kind in this area. Is that enough for us to say, to resolve this case in your favor, or do we need to, I think what Justice Alito is pressing at is, to rule in your favor, do we need to go down this government benefits route?
I mean, I think federal trademark registration dates back to 1870, so it's been around a long time. It hasn't been around since the founding.
Well, there's common law before that, right? It's not like this came out of the ether.
I mean, there certainly has been a long tradition of thinking of living individuals as having certain proprietary rights over their own names. And here the question is not just whether Mr. Elster can use Donald Trump's name, because he can. He can market expression that is about Donald Trump. The question is whether he can assert an exclusive right to use Donald Trump's name and prevent his competitors from doing so. Now, another answer I would give to Justice Alito is an important limitation on our argument here is that Mr. Elster can sell shirts with the slogan Trump too small, and he can obtain federal trademark registration so long as he uses a different source identifier that meets the statutory criteria for registration. And that's an important limitation, because the court in recent decisions has, like AOC, has cautioned against conditions on government benefits that seek to leverage
no, please, your turn. Have at it.
Keep going.
I suspect we're headed in more or less the same direction. The word government benefits again came up, and I guess I'm just asking, if I look back to the common law of trademark, okay, and if I look back to the earliest trademark statutes, I see a lot of what we now maybe describe ahistorically through our First Amendment lens as content-based. There are restrictions about geography, merely descriptive things, and living persons' names. Those have always been areas where there's been some limitation on the ability to trademark. And I guess I'm asking, why not just look to the history here and see whether historical evidence comports with this being a First Amendment liberty or not?
I mean,
why do I need to go down this, because the government gives it to you, it can do whatever it wants with you, road. And it's a very difficult and fraught road. And we have unconstitutional conditions doctrines and a million other things in this area. And I'm just not sure why I need to tangle with any of that.
I mean, certainly if the court feels that the historical evidence is sufficient to decide the case in our favor, we
don't object to that.
We don't object to that.
Just checking. All right.